we continue with reaction now on the news of the rescission granted by the Constitutional Court regarding former President Jacob Zuma. We are joined by Jacob Zuma Foundation spokesperson, Mzwanele Manyi. Very good morning to you. Thank you so much for your time. You had pinned your hopes on a more positive outcome. What's your immediate reaction?
Yeah, good morning, and to the viewers of the Newzroom. Indeed, we are disappointed, although this decision is not unexpected. Already President Zuma's rights were violated by this excessive delay of almost 3 months. That on its own is travesty of justice. And to come to this kind of a decision where it was, more than once, it's clear that the court places its own importance, its own self-importance over more than the importance of the rights enshrined in the Constitution of the people of this country. This Constitution was made for the people of South Africa. Now, if the people of South Africa, whose rights are in the Constitution, are going to be just waived just because we have to maintain the dignity of the court, and as you maintain the dignity of the court can just decide to not to use procedures that have been set out to dispense justice in a fair manner. We really can't accept this decision. It may very well be the last decision, but it's a decision that we continue not to see its rationale. It's a decision that, in fact, amounts to bullying. This is what this is really all about. It's just
but Mr. Manyi, the court here is saying that the application was made on the basis, in terms of Rule 42, which says that the court may vary or rescind its ruling if it's granted in the absence of the affected party. But the court is clear here that the former president was given all the opportunity. In this instance, it was elected absence. Those are the words that they used. That he was given an opportunity and he failed to take that. How do you respond to that?
I think it's important for you to make a difference between whatever court rules and whatever versus the Constitution. The Constitution is a superior law of the land. Nothing that violates the Constitution is constitutional. Now, if you have a Constitution on Section 12(1)(b) that says no detention without trial, and we have a constitutional court that condones a process that does not entail a trial, that on its own cannot be constitutional. If you have a Constitution on Section 35, Paragraph 3, that gives all kinds of rights to people, and then you have a constitutional court that makes a dispensation to waive those rights, that can be constitutional. It doesn't matter what the rules say.
But the court here...
If you have a court that is going to decide to give you an opportunity to mitigate a sentence, even before a sentence is given, that on its own is unconstitutional, because you can only mitigate once a guilty verdict has been pronounced. Now, you can't have a situation where a court is going to say, we gave an opportunity before we hit you. That's not how it works. You must first hit, then you can provide mitigation. Now, you can't have a situation where a person is like making their own homework because they know that they are not going to give you mitigation.
I think on the very last point you are making there, Mr. Manyi, where you are saying that by granting, remember that in April, actually, the former president was given an opportunity to file an affidavit by the court, which he did not take. But then the court was clear in saying that while he did not take that opportunity, in trying to come to court now, he was trying to do what he had refused to do in April, effectively.
No, I think you're missing the point. Here's the point. The court, in the first instance, should not have had the business of entertaining this application. The court should have taken the same decision it took when Colin Khosa's case of murder by the South African Defence Force, National Defence Force, was presented to them. They rejected it, they dismissed it, they said it belongs elsewhere. When the DA brought a case of the Disaster Management Act regarding this pandemic that is killing people internationally, this court made the decision that, no, this thing does not belong, it belongs elsewhere. So if you look at those kinds of cases, the weightiness of those cases that were dismissed, what was so important was just a mere contempt of court, compared to people that have died in the pandemic, compared to a Colin Khosa that have died at the murder of the South African Defence Force. If those were not important enough for the Constitutional Court, why was an administrative issue so important? Why was it so important? Is it because it was headed by one of their colleagues? I mean, this is a travesty of justice. This cannot be justified.
Now, Mr. Manyi, here's another issue. Mr. Zuma is due to be in court on the 21st and the 22nd of May, and we know that he has been granted a medical parole. That's where the Pietermaritzburg High Court will be hearing his application for the lead prosecutor, Billy Downer, to recuse himself. Will Mr. Zuma be in court, and also what state is he in now? How is he health-wise? Is he fit to be in court effectively?
Just before we get there, it's also important, because this today, let's finish with this one. It's important to say the judgment by this Constitutional Court today will also undermine investor confidence in South Africa in this way. If you have Section 39 of the Constitution of this country that says that courts should take into account, the word they use there is must take into account international law. Then you have a constitution. Then you have a Constitutional Court that decides that it's not going to be obliged by that international treaty. What that means is that the international rules that South Africa has signed with the other partners internationally, international rules that South Africa has domesticated in its supreme law of the land, the Constitution. Then you have a ConCourt that says they're not obliged by that kind of a dispensation. Sorry about this. By that kind of a dispensation. That means that you cannot trust the rule of law of South Africa. You cannot trust what is in the Constitution of South Africa, because you've got justices that can decide that it's not important enough. So we argue that that it's bad even at an international level to have this kind of a situation.
Mr. Manyi,
so moving on to a question.
Perhaps before we get to that question, let's round off the discussion with this matter. The order also speaks to costs that are involved, costs that pinch on the former president's pocket. What does this now mean with those costs that will be hanging over the former president's head?
Look, I think having been bullied into this situation, we will be bullied to pay the cost, and we call upon South Africans to concede that we have no other option but to pay these costs. That is not negotiable. So we call upon South Africa. We've already advertised the Jacob Zuma account, where we ask people to make those contributions to be able to settle this account, because we have no other option but to pay this account. So we have to do that. So that is not a debate.
Now, Mr. Manyi, you can respond to my earlier question about the court appearance on the 21st and the 22nd, and whether the former president will be in attendance, whether he's fit enough to attend court.
We'll make an announcement about that tomorrow.
Okay. That is Jimmy Manyi. He's a spokesperson for
Mzwanele
Manyi. My apologies for the Jacob Zuma Foundation there.